Hi, this is Module 12. This is about tort law. First off, tort is a civil wrong. That's kind of a short definition for tort. A little bit longer definition would include that it's an injury resulting because of someone else's conduct that is legally actionable. There's two types of torts. One is intentional. Those are things like assault, battery, false imprisonment, defamation, and then there's unintentional or negligence. Those type of torts, the ones that meet negligence, have to meet four elements. The first being duty, which talks to the fact that as a school teacher we have a special relationship with our students and we are serving in the parent role when we have them or when we're taking care of them. And then the second element is when we breach that duty, which has to do with reasonable care and doing what most other people in your position with life experience would do in that situation with that age group and with that student. And then proximate cause has to do with foreseeability and whether or not someone could foresee the possibility of an injury occurring. And then the final element is, for it to be considered negligence, is that there has to be some type of injury that has occurred, whether it be mental or physical. Okay, then the first case that I looked at was Collins versus Bossier Parish School Board, and this is a negligence case. In this case, Eugene Collins was injured during kindergarten recess while playing on the monkey bars. Another student, Malaby, wrapped his legs around Eugene, causing him to fall. Collins' father argued that there wasn't adequate supervision as there was only one teacher for approximately 85 kids out on the playground. This incident occurred in 1985. As anyone who's observed kids on monkey bars know, that's pretty common for somebody to wrap their legs around somebody else and try to get them to drop. This particular case, the initial decision, one of the decisions was against the school board was dismissed. The liability was dismissed because the judge didn't believe that additional supervision provided by the school would have prevented the injury. And then they did award damages against the father of the boy, Malaby, who had wrapped his legs around another student for $13,000. Then if we look at some reactive measures of what would have happened, first off, in my school, in any school I've taught in, one teacher for 85 kids has never been considered appropriate, so immediately there would be more supervision included. Some proactive measures that I would like to take is if the wording isn't included in the current playground rules that state that students may only attach themselves to the monkey bars while playing on this piece of equipment, it should be added and taught. So that should be added to the rules and then taught to all the schools. Professional ethics, I would want to make sure that that we have good playground rules in place and that there's a rule for each piece of equipment and that those rules are taught at the beginning of each school year and retaught as necessary throughout the year and that they're revised yearly as needed. Those kinds of guidelines and that kind of follow through would help eliminate any kind of tort from occurring. I would hope that's within reason and would give you a likelihood of doing your professional duty. Oops, went the wrong way. In the second case I looked at was Buzzard versus Eastlake School District of Lake County, California. In this case, this was an interesting case, and I specifically took it because it took place in 1939. And sometimes I think it's interesting to look at older cases because they kind of give you clues into why some things are the way they are today. And this one is this is a good example of that. Donna Mae Buzzard was a 7-year-old who was injured when a student on a bicycle ran her down and ran over her leg while she was playing on the playground during recess. The other student was also participating in recess at the time. Anna Hull was a teacher who was supervising recess, and she wasn't 50 feet from the incident, so she had good proximity to it. The two boys had been allowed to ride their bikes on the playground during recess for the last couple of months. The school district argued contributory negligence on the part of Donna Buzzard, which I found kind of comical, because how do you blame a little girl who's playing on the playground for a boy who purposefully runs her down on a bicycle? She was awarded $1,500 in this case, and the court ruled the district failed to maintain a safe school and found them liable, which, in my opinion, they should have. If this were to happen at my school, first off, there's no bicycles during recess. Bicycles, there's rules about kids who ride bicycles to school, and they're not accessible except for before and after school. And even then, students are expected to walk their bicycles on the sidewalk, so this wouldn't have even occurred. But if it did occur, you would make sure that kids weren't allowed to ride their bicycles during recess. Some proactive measures that I'd like to put in place to prevent this from happening again would be to create rules for passing around other children who are playing during recess. And this is something that I've seen. Kids often, like if there's a kickball game going, they just run right through it instead of going around it. So put some rules in place so that kids know how to act about going around other kids. And then some professional ethics. I think all recess rules and guidelines should be created ahead of school starting and revised each school year as needed. Create a safety committee that advises on playground safety, and have them constantly or yearly revising the playground rules as needed. And the principal should also frequent the playground to check for compliance. Number 3 is Mosley versus Portland Public Schools. In this case, high school student Cassetta Mosley became involved in a fight upon returning to school from lunch. Wanda Griffin stabbed her several times with a box cutter, and she suffered permanent scarring. The incident occurred in the hallway where there was no supervision. The defense argued that the school had failed to provide adequate supervision, security, and failed to stop the attack. In the case I was reading from the Supreme Court, they affirmed that the school district was not liable. So in this case, they found that it wasn't their fault. You couldn't have predicted that a student would come out of nowhere and attack another student with a box cutter knife. However, having had this happen, well, not have this happen personally, but if this were to happen in my school, I think teachers would be asked to be more visible in the hallway during any passing periods. And some proactive measures that I've put in place is to make sure that a plan is in place for teachers during passing periods, including lunch, so that all areas are as well supervised as possible. And then professional ethics, I think there always should be a yearly schedule for supervision, as well as the guidelines for teachers during passing periods, so that everyone knows the expectations. If weapons really are an issue, then we might have to consider metal detectors and other kinds of ways to protect kids from weapons coming inside the school. I think you have to look at your specific school to determine that. In the fourth case I looked at, it was Sidwell versus Briggsville Community School District. Bryce Sidwell, who was a minor, was injured on the playground when he fell into a large rut that had been created. The plaintiff argued that the district had been negligent in not filling in the rut to prevent student injury. On appeal, the plaintiff had removed the section of the case against the teacher for neglecting to instruct students to stay away from the rut, which seemed to play an important part of this case at the point where it got to the Supreme Court. I think they probably could have proven some negligence against the teacher, but they had withdrawn that part by the time it got to the Supreme Court, and they decided to just go after the school district. The Supreme Court dismissed the case as they didn't find willful or wanton misconduct on the part of the school district. I think that in this case, some reactive measures that need to be put in place is that the ruts need to be taken care of immediately, and teachers need to be advised to keep students away from the area, any kind of area that has a safety issue. And a teacher should be, if the safety isn't corrected, then a teacher should be placed in proximity of that area to help keep kids away from it. Proactive measures that I would put in place is to include something in the playground rules that states what should occur if a safety hazard appears on the playground, and discuss this with teachers and have teachers annually cover this with students and re-teach as necessary. Professional ethics. In this case, I think that the district groundskeepers, whoever they may be, there should be a policy in place for safety and what specifically is their responsibility if they see a safety concern or if they create a safety concern, and that they should notify the building principal immediately and make immediate plans to rectify the situation. And the fifth case I looked at was Stevens versus Des Moines School District. In this case, Danny Stevens, a middle school student, was beaten up in the hallway by Sean Harris. Harris had a history of being aggressive, and there was reason to believe he might come after Danny Stevens that day. Harris mistakenly thought that Stevens had called him the N-word. The plaintiff believed the school was negligent in controlling Harris and protecting Stevens from the attack. There was an issue with Stevens allegedly hitting his own head. So there was a little bit of confusion, and it brought into the case of hearsay because another student said that Stevens had, after the attack, had hit his own head. So that brought into concern about whether the actual beating had happened or not. This lower court initially found the school district liable, but later reversed and remanded it back to the lower court. If this were to happen in high school, I think we need to make sure that we have accurate records, probably by the nurse, that are being taken anytime a child is injured. Always refer students who are hurt to the nurse and send an adult with Harris during passing period. So if we have a student who we know is aggressive, then we need to do the best we can to get him where he's going with an adult. What proactive measures would you take? Appropriate supervision in the hallways during passing periods, provide escorts with students who are upset, take accurate records in all injury-related events. In setting professional ethics, we need to have a protocol in place for handling students with aggressive behaviors who are a danger to themselves and others. And we need to have a protocol for supervision in the hallway. And then we need to have some kind of a protocol for documentation of injuries. All of those things would help keep us and prevent torts from occurring. And then here are my resources. Thank you very much for your time, and have a good day.